37.
Just a
My lord,
minute.
I am appearing on behalf of NBCC in item 37, my lord. So your lordships has issued notice in IA number 260426. We have just received that IA from
You
them.
can also file.
So we will file the
I
Wakalam and
counsel and counsel for the MBC
With Kumar
6 weeks and granted 2 weeks time.
4 weeks time.
4 weeks time to file the counter affidavit. And then say, having regard to the nature of issues that are likely to arise for consideration, we appoint the Rajiv Jain, advocate, former director IB and former member of the National Human Rights Commission as the amicus curiae in this case. The learned amicus, Mr. Jain, in this case also you will have to help assist us. The learned amicus shall be entitled to the same amount of honorarium and facilities as have been ordered in so and so case. Just give that order where we have fixed the honorarium so and so. The same shall be disbursed by the builder, developer, in bracket Mahira Homes. The registry directed to provide a complete set of the paperwork, including all the IAs, etc. to the learned amicus, soft copies kar dena. Counsel for the parties are also directed to contact the learned amicus and ensure that and see that of the pleadings complete in all respect are handed over to him. Then say post this matter for further consideration after 4 weeks on so and so day.
No, just a small request, your lordships, in item 37.
Give a fixed date in this after.
No, in 37, a small request for my lord's consideration, where your lordships are asking NBCC to file a response. Let them specifically deal with this aspect, whether they are in a position to revive the project or not.
We hope they will, if it is mentioned in the application, they will reply to that.
Yes, today only we have received that IA, my lords, and
Let's
currently we are
hope
not in a
they will
position
respond
to
to
give it.
Grateful, Lordship.
So-
Grateful.
Deeply obliged.
Madam, 37.4, I filed application.
Fixed returnable date.
We are taking one by one items.
37.4, my lord.
37.4, what was that?
Moved application for implement on behalf of landowners, my lords. That agreement was,
In that Mahira Homes matter.
please, my lords, sector 104, my lord.
You are landowners.
Landowners, my
Your
lord.
lands have been taken, nothing paid.
Paid 20 crore check was dishonored. There is nothing, no development on the land, my lord.
Say IA number so and so, give the IA number.
Please.
IA number so and so has been moved by the landowners who allegedly entered into an agreement with the developer builder developer without going into the contentious issues raised by them. It seems to us that they are necessary and proper party to be heard in these proceedings. The IA is accordingly allowed, and the applicant owners are ordered to be included as respondents so and so, so and so. The newly added respondents may file their counter affidavit within 4 weeks.
But my case is that there is no agreement as of now.
Today your case. We are impleading you, please file your counter.
Very well, very well.
Why it is necessary today itself? What is my case? Yes, any other IA in that case? Now item 39.
Your lords, can it be on a fixed returnable date, item 37?
Hmm?
Can it be on a fixed returnable date?
We are giving you date, madam. Please. By the time you will get up from the court, you will find a date. We will upload the date.
Lordship.
Item 39.
Yes, your lord.
39, there was a detailed report
Filed by the amicus,
was
my lord.
filed, and we had circulated a note yesterday for convenience. We had circulated a note yesterday, my lord, summarizing the report.
Of
You would
the,
have a copy of that.
Yes.
your lord.
of the report of the learned amicus.
Yes, last time learned amicus had filed a detailed report.
Huh.
So for my lord's convenience,
But we will like to learned amicus
Yes.
will explain his report.
very well, my lord.
Let the author
So-
speak about the documents he has done, and the report itself is of course self-explanatory.
It is a tremendous work done, at least that much we should say, my lord. Each word and each page that he has put in, my lord, speaks tons. So we are grateful for that report, my lord.
That's a commendable job. Now, Mr. Jain, can you now just flag or point out the directions which you require as an interim measure right now in the matter?
Sir, before the mic,
Your lordship, may I just submit one thing before any directions are passed? I appear for around 900 home buying. And your lordship, the report is very comprehensive.
And most parts of it, your lordship, the interest of the home buyers would be taken care of. But there are certain aspects where we have also something to propose.
No, we will, yes, we are aware of this fact that all of you were on the previous date of hearing permitted to give your viewpoint, your suggestions, your ideas to the learned amicus.
Yes.
And those have been, to our understanding, those have been adequately taken care and have been effectively addressed in the report.
Indeed.
But maybe there is still some supplemental arguments or assistance you might be required from your side.
Yes, my lord.
But let us see what are the kind of directions the learned amicus will ask, and is there any difficulty or what kind of inconvenience it will cause to.
Absolutely, your lordship. Once the ICAS has made its suggestions, just hear us out, because 900 home buyers who are yet waiting for their apartment, your lordship. They also have some suggestions.
His entire, the purpose of his report is also to protect the interest of the home buyers, number one.
Yes.
To protect the public money, to ensure that those who are indulging in kind of this, if at all if somebody is indulging any malpractices, collusion, connivance, whether it is the bank officials or other financial institutions or the builder, that the law must take its own course, that's all.
Yes, very good. So, your lordship, in this case, there is one peculiarity also which needs to be kept in mind. This is a standalone project where I'm appearing for 900 home buyers. It's not a case of a group like Amrapali, Unitech and others, your lordship. And in this, your lordship, there is a code developer. I also wish to place certain portions of Amitabh Kant's report, which dealt with such issues where an existing project cannot be completed. How can it be completed and what measures need to be taken? So the learned amicus has suggested certain models. So we are proposing one model from the amicus report only, with certain changes that are required. Your lordship may hear us on that, your lordship. And that would safeguard the interest of the home buyers, and we'll be able to get our homes and residences.
It will be implemented. This Noida authority. Thank you.
This report has been circulated to all of you.
Yes, yes,
The new Noida, I believe, has filed something today or yesterday. I don't know. Yesterday late night. So we would like to have a look at that.
I am appearing for Noida, my lords. I have filed a report last evening, my lords, and there are some
That is not with
observations.
us.
Yes, my lords, it may not be with your lordship because it was filed late night, my lords.
No. Is that report a kind of a counter or in a position to what the learned amicus has submitted, or is something entirely new?
No, we are saying, my lords, the only thing is that the entire report is very comprehensive. That's not a problem. But the only thing is that as far as the payouts to Noida is concerned, that has not been considered at all. They are saying that everything will be paid later on, and lordship, we have to give all the facilities and all the external developments have to be made. So the provisioning for Noida's dues have not been taken into consideration, my lords. So that was precisely the intent, and your lordship, we have given already the comments. To
Have
the,
you received that report?
On this Noida report, sir, one thing which is starkly brought out is that OC, that is occupancy certificate, was issued by the Noida authority in July 2018 for 582 units, dwelling units. However, registration of the sublease deed was done only in respect of 82 dwelling units. The rest were not done on the ground that for the financial year 2019-20, requisite funds from the developer towards license fee and other things were not remitted to the authority. Now, the point here, sir, is that OC was issued in July 2018 when the dues were already completed at that point of time. But registration is not being done for dues pending for the subsequent financial year. Also,
Yes.
in this respect, it is relevant that in the Lotus case, the Allahabad High Court has passed a judgment seriously berating the Noida authority for not registering dwelling units which are ready for occupation. Earlier too, this honorable court in the Amrapali and Unitech case had taken the authority to task for not registering the dwelling units. So in this particular matter, sir, particularly in respect of those 582 units for which OC has been issued, there is no reason why the authority should not register those flats. Registration is necessary because it will provide liquidity in the market. It will provide confidence to the home buyers. There would be some buying and selling taking place.
That's it.
If I may say one thing, Manoj, in this, there has been an application which was filed.
Now, ultimately, in your analysis, what are the recommendations you are making, Mr. Jain, if we can make them as an interim measure?
So,
May I just-
Lordship, I have submitted two reports, one dated 12th September and the other dated 12th November. The 12th November supplements the earlier report, but most of the recommendations have been factored in the subsequent report. So I'll read out the highlights of the reports. The first point, sir, is that no case for any.
Sorry, Bharat, sir, I don't want
has
to
been
interrupt
laid
us,
out.
my learned friend, but are we proceeding with the hearing?
No, we are just.
Because that Noida thing has just come late last night. I don't know whether your lordships, but I
May-
certainly haven't had a look at it.
May I say something, my lords, in this? May I say something? The day before yesterday.
This aspect, I'm supporting the amicus, that these 582, etc. We've made an application, in fact, to Noida saying that there must.
So I am
There
coming.
In fact, if that, my lord, can consider as an interim measure,
We were only thinking, we will not hear the case full fledged today, it can't be. We thought that if whatever some interim measures are required to be made, that we can probably.
May I just suggest, subject to what the amicus and what the court feels, it will require even for the interim measures some length of hearing. It will require some length because it's on many aspects or on certain aspects we are supporting the amicus. On certain other aspects, your lordships will have to take a call. There was a tentative observation which the court had also made as to whether there should be a committee, etc. So I'm sure we will all have submissions to make with regard to this, and then we can move forward.
Then we take up next week.
Your lordship, may I say one thing, my lords? What has happened that day before yesterday, I was served with a copy where the registration has been sought and from Noida. So lordships, I may file a reply. Let a version of Noida be
On
copied.
registration part, yes, you owe an explanation about the registration of these units.
Yes.
Why it was only, despite if it's a project of 582, then why
Yes.
the registration was restricted
There,
only to.
yeah. Yes, I will give the explanation, my lords. What has happened that
Find out.
yes, should I tell now, my lords, or should I file it? What was the reason?
In fact, my lord, an
We'll take
application,
up the next, we'll take up this matter next
Lord,
week.
on this
All right.
issue, on the
I just
registration.
request next Tuesday because I'm not here on
Yes,
Wednesday
Lord.
and
On
Thursday.
Wednesday,
I request next Tuesday.
Subject to your lordships.
Tuesday doesn't read.
Next Tuesday,
No, next Tuesday I'm requesting.
Huh?
Next week on Tuesday because on Wednesday, Thursday I'm not here.
take up on ninth.
Ninth, I'm grateful. I'm grateful.
Grateful, my lords.
Lords, in the meantime, on the registration application, Noida Authority may file its reply, my lord, or take instructions, because this application had come up on last date also, where they
I'll
had
do that, my lords.
taken time, my lords, to take
I'll do that.
instructions.
in fact, that is really the interim measure my lords may consider because people have been waiting for their
Lord,
registration for the past
85
5
flats are registered already. Out of 582, 85, 5 are registered and remaining are not registered. OC, as Amicus has said, is already issued in 2018.
In what?
So as an interim measure, my lords, your lordships have held in Lotus case, my lord, that a nodal officer was appointed at Noida and registration was directed to be commenced, my lord. So as an interim measure, my lord, because ultimately my lord's objective is that project be completed. Lord, if registration
That's
happens,
why learned amicus has recommended constitution of a monitoring
Committee.
committee by this court,
Committee by a
under whose supervision the project can be completed. That probably.
That would be a fair, that is a fair
my lord,
suggestion.
we are okay with formation of a committee as an interim if my lords consider.
The banks are represented by, the financial institution don't have any issue, as such.
No, my lords, I don't think banks are already here.
I am for the
Maharashtra.
RP.
The Lordship
I am
will
for
have
the
to take a
RP, my lord.
comprehensive call even at an interim stage. But on this aspect regarding registration, we'll make our submissions on Tuesday. At least we are definitely supporting maybe more than 500. I will take instructions.
In fact, I am told, my lord, the builder has also made a representation to Noida to
Yes,
start
we made a
registration. So
representation.
far as the completed flats are concerned, my lord, we are not talking about the flats which haven't seen the light of the day. My lord, in this project, 582 people are living since 2018 and registration is not happening, my lord.
Next, you grateful.
Mr. Mittal, you have instructions about that, huh? All right, we'll take up on 9th.
I am grateful, my lord.
Grateful.
Lord, in the
Ninth is. Can it be on 10th if 9th is difficult then the very?
Right.
10th?
9th,
Ninth.
Tuesday.
Very good.
Yeah.
Very good.
may I make a request, Lord, in the
Yes, Mr. Kumar.
SIR matter, my lord, Kerala matters were kept today, my lord, last week. My lordships allowed for the interim part.
Election results will be on 13th and 9th. 11 elections.
That is item 28, my lord, Kerala, they have filed their counter.
Not in Kerala.
Lordship, please.
Yes, my lord, a reply is filed and my lord, the apprehensions, my lord, your lordship would appreciate there is no scope for any apprehension. But Mr. Dwivedi is also connected, my lord. My lord, the reply is filed. 88% as of yesterday, the even digitalization of the forms having been received is completed.
No, can you do one thing? Say to the extent of, Mr. Dwivedi.
Is there, my lord?
Yes, my lords.
You see, Mr. Kumar, are you representing the state government or?
No, my lord, I am not that CPM secretary, my lord.
I am for the state.
The state is, my lord, my friend, Mr. Sasi appeared, Mr. Sibal is appeared.
Have you also filed a petition?
Sorry, my lord.
State has not filed any petition.
Yes, state has filed a petition, my lord.
State has not.
That is item 40.
The reply is in the petition.
By the state?
Yes, my lord.
You are also seeking deferment
Yes, my lord.
only on the limited ground that you are, right now, your manpower is busy and engaged in the
Yes.
local body elections.
Yes.
Right?
That's on 9th.
Yes, because that, there is
not. Panchayat and 11th is the municipality election and 13th is the counting. So, my lord, there are.
13th of December.
Yes, my lord. The nomination was filed on 21st of November and, my lord, 9th and 11th are the voting and 13th is the counting.
Mr. Maninder Singh.
The booth level officers.
You may continue with whatever your process is going on, but you don't ask the government staff or the employees which they have engaged in the election duty. You please don't ask them to come.
The state itself has separately allocated 25,000 only to the Election Commission of India for this first phase, namely enumeration form distribution and sign. The local body election conducted by the State Election Commission is concerned, they have allocated 176,000 workers to them. So there is a complete separate allocation of staff to them. However, we are coordinating with the State Election Commission and we have told the commission that whichever
Mr.
staff...
State Council, is it correct? What
Yes.
Mr. Dwivedi said?
No, my lord,
That
no.
1 lakh odd staff members you have allocated to your State Election Commission. We will tell them not to call even a single person out of them for their exercise.
My lord, I am
You
for this.
continue with that staff, complete your election. Whatever
Yes.
you have, as per your own choice, you have given to them, let them continue only with that much staff.
My lord, I am for this. You should clarify that, my lord.
Just one more thing,
Clarify
Lord,
that
that
they
in any
should not,
Or you tell us, just a minute, or you tell us out of, how many staff people have been given to you?
Lord, 25,468.
29,000. If out of these 29,000, Mr. State Council.
25.
If you need 1,000, 2,000, 3,000, 4,000, we will tell them to spare them also till 13th December.
We have already told the State Election Commission that you take any staff which you.
I am for the State Election Commission. I filed
Just a minute, please, we are trying to solve a problem. We'll hear you. Hopefully we'll be able to resolve it. They are not a serious issue.
We are not going to take any staff.
Yes, my lord.
Please, can you point out that 29,000 odd staff you have given to Election Commission of India?
25,068.
25,468. 1 lakh odd. Is there any request with you by State Election Commission that they need more staff?
Yes.
Is there any request?
No request at all.
No, that is not, no, my lord.
Do you have done any your own evaluation or homework to say that you require more, this 1 lakh odd staff which you have given to State Election Commission, you are required to provide more manpower to them? Is there any such exercise undertaken by you?
The problem, my lord, both are continuing at the same time. The SIR and the election, my lord. Anyway,
Election of local body has nothing to do with asking people to fill up the form.
because there is an administrative ambassador, my lord, large extent of employees are now involved in SIR and election, my lord. The problem is it's not simultaneous. My lord.
They say 88% work is already complete. Then who is asking, who is complaining?
As per their own affidavit, 91% of the forms are distributed, my lord. This is a large exercise. They need to upload this.
What is your last date?
Milos, the last date for enumeration form was 4th, which we have already extended. Keeping all this in mind, we have extended it by 1 week, so 11th. And on 11th, their election will be over.
No. Their election is on 13th.
9th and 11th.
Now 13th is only counting.
Counting, my lord.
So you extend your date, you extend your date 1 week more beyond 11th so that any left out person who is busy in the state election, they can also get an opportunity.
Yes.
Milos, your lordship need not worry. Let them. Nobody is agreeable except for the state saying about employees that nobody has come forward to.
Anyway, Mr. Dwivedi,
There is no urgency.
if somebody is busy, suppose in the state election, some officers might be occupied. They also would like to enroll themselves in the.
Your lordship, kindly have it on 10th. If your lordship still feels that, my lord, we need to extend, my lord, certainly, my lord, there's no problem. So kindly have it on 10th. Supposing, my lord, everything gets completed on both sides.
Tell the state government to submit a request to you. And you consider it sympathetically and then.
If I
That's
just
right. Let them send it. Let them send.
The State Election Commission and resolved. State Commission is submitting before your lordship that we have no problem with 11th of this.
Who is representing state elections? You are representing. You don't have any problem.
We have filed an affidavit saying that the staff deployed by us is exempted from the SIR duties. Therefore, we are not facing.
But this simultaneous, my lord.
25 for the purpose, not if they have themselves put up in the form.
Kumar, the government machinery, the constitutional machinery doesn't have problems. Some political parties have problems.
Only the political party.
In fact, para 19, Milords, in fact, para 19 of
In the Kerala matter, right down.
Milords, in fact, para 19 of the Election Commission's affidavit specifically says that, Milord, the SIR exercise is being carried out by them with the help of 25,000 BLOs and 60,000 BLAs of political parties, both the ruling and the opposition.
The Election Commission.
No, Milords, 60,000.
Yes.
Milords, if I may submit, Milords, for a moment, if I may submit, Milords, I am appearing for the MLA Puduppally Kottayam. Milords, I visited in the last 2 weeks about 2,000 houses, and it is a ground reality about 150.
Therefore, you want to politicize here.
I mean, item 28, Milords, I have visited about 2,000 houses, Milords, 150 houses, even forms are not given.
Duty, you are a public representative.
Yes, Milord, that's what I'm saying. That is what I'm saying, Milords. Even 400 to 450 voters are excluded. They are not even given their forms, Milord. The tenants in these houses are not even given.
You take the forms and give to them.
No, that is the difficulty, Milord. That is why we have before my lordships, Milord, specifically saying,
Thank you very much.
Milord, our interference is becoming is imperative, and we are not able to devote time because of the panchayat elections, Milord. That is why we are saying at least for a week, if it is deferred, Milord, we will be.
Now stop or not?
Milord,
Sufficient enough now, please.
Milord, may I just point out one thing from the affidavit of the Election Commission of India, paragraph 19.
Mr. Kumar, we are granting a window if somebody will allow us to pass an order.
I'm sorry. I just wanted to show, Milord, this.
Write down this batch of petitions are at the instance of the state of Kerala some political parties and individuals, including public representatives. All of them have at this stage, without prejudice to their right to challenge the very initiation of SIR pura likh dena, SIR, have filed these writ petitions seeking a direction to the Election Commission of India to defer the ongoing, what is this process you have started? What you call this?
The enumeration form.
Enumeration.
Enumeration.
Special intensive revision,
The
enumeration.
submission of enumeration forms under the SIR
Yes.
till the elections of the local bodies are completed in the state of Kerala. Next paragraph. During the course of hearing, we are informed by the State Council as well as Sri Ranjit Kumar Land, Senior Counsel, representing one of the political parties, that the elections of the local bodies will be over by 11th,
By 13th of,
by,
because counting is on 13th, 9th
Only
and
13th.
11th are the voting lot first.
will be over, will be over on 13th or soon thereafter, once the counting is complete.
Please.
Once the counting is complete. Next paragraph. Mr. Dwivedi and Sarvasri Dwivedi, Rakesh Dwivedi and Maninder Singh, Land Senior Counsel, representing the Election Commission of India, state that there is no impediment, that the exercise of filling up enumeration forms is causing no impediment in the smooth conducting of the elections of the local bodies, for the reason that the state of Kerala has allocated a dedicated staff of 1 lakh. How much, Mr. Dwivedi?
25,468.
To the State Election Commission.
Yes.
State election?
No, if to them it is 1,76,000.
Huh?
1,76,000.
1,000
I can inform.
staff to the State Election Commission for conducting the elections of the local bodies. Similarly, a separate staff of 25,468
468.
has been allocated, has been placed at the disposal of the Election Commission of India for completing the exercise of filling the enumeration forms. That exercise, as per the extended period, will be over on 11th December 2025. Right? This is the factual position.
Yes.
And
Yes,
88% is over, my lord. By yesterday, it is.
By now,
That is the distribution of forms.
Sir, it is
and
digitized.
by now, my lord said 98.8% of the forms have been distributed and 84.96 are already
88%
digitized.
have been received back and
Dwivedi and
digitized.
Mr. Maninder Singh further informed that more than 98% forms, enumeration forms, have already been distributed.
And 80% is digitized after 88%.
And 80% have been digitized also. The learned counsel for the State Election Commission on instruction state that the State Election Commission does not require any additional.
No, that's not what I said. I said that all the staff deployed by us for the election is exempted from SIR duty, and as of now, our functions are going smoothly without any difficulty.
State that with the allocation of the staff to the State Election Commission, as referred to above, their functioning, the State Election Commission is completing the ongoing local body elections smoothly without any impediment caused due to shortage of staff. Land State Council, Mr. Ranjit Kumar Land Senior Counsel and other learned counsels representing the petitioners, however, submit that some of the political workers, employees, local residents are completely occupied in the ongoing local body election, and if the time period to submit the remuneration forms under the SIR is extended beyond 13 December, it will facilitate them for submission of their respective forms. This is what you are arguing.
Please, my lord. Yes,
You have understood in one line.
yes, my lord. Yes, my lord.
50 times.
I bow down, my lords. I bow down. Highly obliged, my lords.
Also, we find, it seems to us that the aforesaid request is just and fair, and it requires due consideration by the Election Commission of India. We therefore permit the state of Kerala to submit a request cum proposal to the Election Commission of India, citing all the reasons on the basis of which the last date for submission of enumeration forms may be required to be extended for a week or so. Let such a request be submitted to the Election Commission of India by tomorrow.
Yes, we already submitted a representation to the Election Commission, my lord. That is pending with them.
If already not submitted, maybe submitted by
Yes,
tomorrow,
I'll
5
submit.
PM. By tomorrow 5 PM.
I'll.
You will draft it and the competent authority will sign it. Because you are the best person to know all the facts. By tomorrow PM. The Election Commission of India will, we are sure, take sympathetic, objective and objective consideration. We will consider such request objectively and sympathetically and pass an appropriate order by day after. Within next 2 days. Now post this Kerala matter on so date. We are still not disposing these matters, we are keeping it pending.
Yes, obliged.
If our intervention is required, we will do that.
Highly obliged.
Now, we think
Highly
that-
obliged.
Item number 11.
Let's one more factor in.
Now, sir, are you happy?
Milords,
Thank you very much.
highly obliged, Milord. Highly
One more factor in this Kerala matter, Milords. Kerala is a special state where 30 to 35 lakh voters are NRIs, Milords, non-resident Indians, Milords. Now, what they're saying about the non-resident Indians.
About Kerala, any positive picture if you paint, we will appreciate. One state only having 100% literacy.
Yes, Milord. Milords, these are all Middle East people, Milords.
Look at-
What election commission
That
says.
Kerala has to, if there are other states, if you compare with Kerala,
Yes.
how?
But 35 lakhs, Milords, they're all Middle East, Milords. Middle East, Milords, all of them are voters also, Milords. What election commission says is that, Milords, they can actually apply online from there, Milords.
See, this
After
are-
applying online, Milord, yes,
This argument is completely premature.
yes, Milord.
It's only distribution of form,
Just
receipt of those.
let me just tell me my problem, Milords. Now, distribution of forms,
Why
Milords,
don't this problem is also highlighted in the representation?
Milords may say that, Milords, NRIs also maybe that problem also may be considered by the election commission, Milords. They are saying that yes, you can actually upload online from there. Once application is uploaded online, Milords, what election commission says is that when BLO comes over here for physical verification, somebody has to be there, Milords. Now, all of them are there abroad, Milords. How can they be present physically over their homes, over there for verification, Milords? So therefore, then their votes also will be cut, Milords. So this is a very unique problem, Milords.
One or two family members will always be there. Some family members.
Milords, these people, all of them are abroad, Milords.
If the entire
Family is
family
abroad,
has
Milords.
gone abroad,
Yes, Milords.
and they are settled abroad, are they there?
They come once in 1 year, Milords. For 1 month, they'll come, Milords.
No, there is no petition on their behalf. Let them file
There is a petition, Milords.
We'll
My
reply.
petition is on item
We are
number
quite
28
sure.
is on that, Milords.
We are quite sure the Election Commission of India.
Your Lords, may I kindly
Because
have
just
one
a minute,
sentence,
just a
Milords, in
minute.
this
Please
order.
appreciate, just allow us to complete.
Yes.
Normally, when they undertake any exercise, the State Election Commission is taken into confidence.
Yes.
And it is through their machinery that they operate.
Yes.
So the State Election Commission is local State Election Commission. They must be fully aware of these things.
Yes.
We will ask them, we rather expect them to put up any such issue before the Election Commission of India. Let the right time come. If we are quite sure they will address it. If at all, otherwise we are keeping these matters
State
pending.
Election Commission does not have any role in this particular mechanism, SIR mechanism, Milords. They are just busy conducting the local body elections, Milords. Your Lordship may in this order just have this NRI, Milords.
Only because tomorrow in the.
In item number 11, I am appearing for the BLOs, Milord, who are actually on the ground level, Milord. Who are actually working in the SIR matter, Milord. I am for the BLOs, Milord. I have moved on.
Which state are you referring to, sir?
I am in general, Milord, because
BLOs have formed some association.
these booth level officers, Milord, are there in the entire.
BLOs have formed a trade
May I
union.
just submit what my this is rather this is a humanitarian application. Milord. May I submit just
Are you for your safety and security?
yes, Milord, and compensation also, because as per the Election Commission of India, anybody who is on election duty, with great respect, anybody who is on election duty, Milord, and if anything happens to him, they compensate them. But this election duty they have defined after the announcement of the election date. Now here, my lord,
Is
here,
it
my
an
lord,
issue-
actually.
Is it an issue to be argued today? Please,
No, I am only saying that I'm not arguing. I'm on totally, as I said, my lord, on a humanitarian aspect, they are giving.
Please give us one adjournment today because we are hearing a parted matter.
Please.
Please grant us one adjournment.
My IA is there, my lord. In the meantime, they may come.
Service, sir.
I have moved in the main petition. I have moved an IA, my lord, 30.
May I mention?
30.
May I?
Madam Vrinda, please start.
Please, yeah.
There is one more urgent
Come
matter.
to our rescue.
They may come with the.
Pass on a very short note.
There was one more urgent matter.
The argument that I would.
Item 25 is another matter, my lords, the Orissa RERA matter. Orissa RERA matter, my lords, where your lordships had attached the bank account. Orissa, not the election matter, the RERA matter. RERA matter.
Without SIR of Odisha is also.
OSIR. That matter where your lordships had, my lords, attached the bank accounts of the builder. Mr. Maninder Singh appears for that side.
For that,
Vipul.
Bhubaneswar builder,
Vipul.
where the some FIR, etc. were there. Mr.
Now-
Maninder Singh used to appear.
Your lordships had directed.
Did that not gone to that extent?
To that extent.
What happened? They are only interested in the amount.
The money is stopped coming, my lords, every time that the matter is listed.
Your Lordship, have it next week. I'll tell we have 1 second, sir, if I can.
Yes, please go ahead.
These are those.
Why every time when you threat you to send jail, then you release the payment and otherwise you keep on arresting
The
them?
money comes this time, they were sure that the SIR matter is going to go, they've not even done that.
What are you talking, sir?
What I'm talking is.
All right, if by the next date your payment is not made,
Very well.
then remind us,
Very
we will impose cost of equal amount.
I'll do that.
The payment of October is made. I am placing before your lordship. Remember, whenever the checks are presented, they will be paid.
We are in December, October payment is paid, monthly payment had to be made. That's the privilege of the argument. Anyways,
We'll take up in
next week, next
And
week.
I'll ensure my friend, my lord,
the date of 2025.
I am very grateful for that.
Lordship, in the meantime, they may come with the reply because Lordship kindly appreciate. Not they are giving the Lord
My lords.
ex gratia.
Yes, now the vote is called out enough. My lords, I've handed over.
Yes, Madam Vrinda. Yes.
Sorry.
Yes, Madam Vrinda. Yes, please.
I've handed over a short written submission.
Yes.
Could you please pass it to the court? My lords, it's largely legal submissions. The legal submissions, particularly those addressed by Dr. Singhvi, have been very comprehensively addressed. So I will not repeat them at all. I will just supplement a few dimensions to that. My lords, because as my lord knows, there's a Hindi phrase which says, "Hathi ke pav mein sabka pav." So that is where I find myself just now.
I think that part Dr. Singhvi has almost taken care of.
Please, my lords. So I will just add a few.
Though he is not in that way a heavyweight.
Yes. I'll just add a few facets to it. My lords, it fell from Justice Bagchi on an earlier hearing that are these forms not akin to the enumeration form, the declaration form? Are they not akin to Form 6 and others which have required information? My lords, much has been said on it. The only aspect that I wish to highlight here is that the powers that have been allocated under Article 324 and 327, again, something that has been discussed at length. If my lords would look at the scheme of Section 21, I will not go into the details, it's again been addressed, but if 21 scheme, the ROPA Section 21 scheme is looked at, it talks about preparation and revision of electoral rolls. 21.3 is an exception only to 21.2. What does 21.2 actually talk about? 21.2 says when the revision is to take place, when the preparation is to take place, prior to the parliamentary election, prior to the assembly election, and prior to a by-election. That is giving the timeline of when the preparation and the revision is to be gone into. 21.3 creates an exception to the when, not to the how. It talks about the timing, that the time when this is to be gone into, and of course, can it be for the entire parliamentary constituencies, all the assemblies? And that has again been addressed in the aspect of any constituency. So it does actually look into the scheme of the act is such that it takes into consideration that there may be an extraordinary situation. Flexibility should be permitted. ECI should be able to revise for a particular constituency or two constituencies affected by certain extraordinary circumstances. That is the limited scope of
21(3) when read with the proviso. So it is actually therefore only with respect to the timing, not the procedure. The procedure, as it repeatedly says, is procedure prescribed. My lords would just look at one other aspect. It's mentioned in my note also that there is a non-obstant clause. I have referred to two judgments which have been placed here. I'll just make a limited reference to them. It's at page 3 of my note under Roman 3 2b, limited operation of the non-obstant clause.
Where this Indra Kumar
Please,
Patodia.
I'm very grateful, my lords. Indra Kumar Patodia, which is paragraph 18, and ICICI Bank versus Sidco Leathers, which is para 36 and 37, which my lord well knows. It says that the non-obstant clause can only be read in a restrictive manner in the scheme.
And Mohinder Singh Gill is cited in what?
Mohinder Singh Gill is cited everywhere because it really holds the field and talks about the relationship between 324, 327, and I will come to that in a minute. So, my lords, insofar as, no, we don't need to read. And so far as 21(3) is concerned, I only wanted to add this one facet of how I would read 21(3) and why the statute thought of including 21(3). Everywhere else, the phrase used is prescribed. It's again been addressed at length. I would only request my lords to look at section 2H of ROPA, which says prescribed means prescribed by rules under this act. So prescribed is specifically defined and will be confined to the rules. The rules have again been discussed here. When it talks of the rules, the forms, my lords, to address the question of akin, Form 6, which was read at length, particularly categories 7 and 8, which talk of date of birth, what are the different documents, as well as residence, including down to utility bills, ration card, bank passbook. The reason why enumeration form and declaration form are not akin, because the letter and spirit is to be inclusive to universal adult suffrage. And what enumeration form does is to actually embed a structural disadvantage. Those documents have been gone into the documents which, due to my lord's intervention by the order of September 2025, it enabled actually the expectation and the mandatory requirement of universal adult suffrage to be brought into the fold through the inclusion of the Aadhaar card. Otherwise, the manner in which the enumeration form and the declaration form are designed, they're designed to exclude. And there is a systemic structural nature. I will come to that. In fact, I can point that out right away. My lords, I had moved an IA asking for disaggregated data from the ECI with respect to Bihar. If my lords would have the reply filed by them to my IA because the data shows something. My lords, it has been repeatedly said that Bihar SIR has been very effective and successful. How would one analyze that? If my lords would have the reply to IA 251491. 251491, the reply of ECI. It's filed on 30th October. Thank you. Yes. No, the reply is of 30th October. My lords would look at page 15 of the reply. There is a table.
Yes.
My lords has that. My lords would just look at the state total, the last column.
Which page are you?
This is page 15. My lords would have a table of this kind. And just at the bottom of the table is the totals. This is the reply of the ECI dated 30th October. My lords has it. I'm grateful. My lords would just see the state total under the heading electors as per final roll with respect to 1st January 2025 as the qualifying date. My lord would just come to the column which talks of female. The female total on January 2025 is 3,49,82,828. And the sex ratio column shows that it is 914. My lords would then,
This one.
sorry, 3 crore 70 lakh. It's 3 crore 70, I'm sorry, I've read the figure wrong. It's 3 crore 70 lakhs 57,477. My lords would now come to the electors under 1st July 2025. Again, the column saying female. And there is a marked drop. Now comes from 3 crore 70 lakhs, it grows to 3 crore 49 lakh 82,828. There is a drop of 6%. 6% female voters are not present in the SIR, the final roll on the basis of which elections have taken place. My lords would see the last column. This is the ECI data. Sex ratio has fallen from 914 to 892, which is a 6% drop. My lords, why would there be such a sharp drop of female voters? The answer lies precisely in the enumeration and declaration form. The nature of documents that is being asked for.
Fall in sex ratio, this fall in
is only vis-a-vis voters, male voters vis-a-vis female voters. They also make a computation because nowadays, as my lords knows, there is a lot being said about women voters, and it is very good. Women are voting in large numbers because there's a lot at stake for them in what is happening. So with this drop, where does this drop come from? And this was an apprehension that right from the beginning has been voiced, that different...
Maybe there, any point of time, this column used to be there, column number 15. Was it earlier there?
It's been there since January 25. That is what the ECI has supplied us. It was there in January. In just 6 months, there is a drop. A person who is on the rolls, women who were on the rolls in January 25, in the summary revision conducted by ECI, and fall out of the net and are no longer voters. So it is just in 6 months, and the answer therefore can only be the SIR. Just open that calculator here.
But does not appear to be very significant. Does not appear to be very significant impact.
My lords, there are so many adult women.
Because what possible is that from right hand side, some shifting to left hand side.
My lords, in 6 months. In 6 months, so many women could not have got married that there is a 3 crores, 7 lakhs, 70 lakhs, 47 lakhs.
The reason is that from 904 in July, here it is 910. So if the 6 have increased there, and there it was earlier total was 893, here now 892.
My lords, that is the ratio on the whole figures. If my lords would just have a glance under column 14 of January 25, which is the absolute figures, which is 3 crores 70 lakh 57,477. That drops to 3 crores 49,000. So from 70 lakhs to fall to 49,000 is a marked drop. And this is only in the period of from January 25 roll to July 25. It's not over a period of time one can understand that there can be. My lords, in fact, there are reasons in lived reality which impact women very differently. And that is why any exercise of this nature will have to take into account whether a person is poor, won't have documents, is a woman, is homeless, etc. If my lords would just come to page 6 of my written submissions.
Page
6. Roman numeral 7, 2. Women voters are systematically disadvantaged. Women encounter distinct barriers arising from post-marital relocation, inconsistent identifiers, and lack of educational records. NFHS data confirms that only 28.8% of women in Bihar have completed 10 years or more years of schooling. The SIR's design does not take this systemic gender disadvantage into account, unlike the inclusive tenor of Form 6, particularly because of patrilocation that follows marriage for women. And therefore, to be able to go to the Sarpanch and get your Vanshavali or family genealogy is not possible in the village that you are now living for an adult married woman. And therefore, there is a particular systemic disadvantage that women are going to suffer, for which there was no accommodation made in the SIR, unlike Form 6, which by the very provision that a range of documents can be provided, including self-declaration, takes into account these variances in people's lived existence. My Lord, leaving that aside, which I do think is a sharp comment on the success of SIR that has been projected here, coming back to the law, from section 21, when it says prescribed, again, something that has been addressed, I will simply touch upon it, is section 28, which says that the Election Commission is a consultee. The rule-making power vests exclusively in the Parliament. My lords, what has been the procedure for all these years? There have been times when there were legislative vacuums. For instance, in the symbols order. What has the Election Commission required to do? The central government places it in Parliament. 28(3) specifically says notification in the Gazette, and prior to that, laying before Parliament. If the ECI feels that today there is a need to have a different form, there is a legal process. Their hands are not tied. They are a consultee. They can advise the central government. The central government has to go through and make sure the will of the people mandates this and not the arbitrary whim of the ECI. That is the distinction being drawn. My lords would just see, again, AC Joes was read. The directions in para 25 were read. I want to draw the attention to the facts of AC Joes, that in what facts, which today we may consider that, oh, this is simply a technological advance. Where in Kerala, the EVM was being used in certain polling booths for the first time. No change in electoral roll, no change in any process of elections, except the manner in which the vote will be cast. They moved from the ballot paper to a technically advanced form saying EVM, and the Supreme Court said, no, I just want to draw your attention to para 1, para 4 and 5. It's a 3-judge bench judgment, as my lord knows.
Para 4 and 5?
Oh, para 1, 4 and 5 of AC Joes. Please hand over AC Joes. The list was given. No, there is a list of judgments. It has already been referred by Dr. Singhvi at length.
It's there in the compiling.
Page 31 of Dr. Singhvi.
It's the Fazalali judgment.
Just open my eyes in judgment. My lords has.
Please go to.
Please, my lords. This election appeal has been filed by the appellant, who was a candidate for election number so-and-so in Kerala, but was not elected. 6 candidates contested. We can leave all this and go straight to the middle of the para. The first secured so many votes were cast manually according to the conventional method provided in the conduct.
What are you reading?
I'm reading para 1, my lords.
1.
I'm reading para 1, just to point out that even for that little change, the court said this power does not belong to you. Mistaken. In the middle of the paragraph, of the 30,000 so many votes, so many were cast manually according to the conventional method provided in the Conduct of Election Rules 1961, made under the Representation of People Act 1951. And so many votes were cast by means of electronic machines. This was done in pursuance of the direction issued by the ECI. by virtue of notification published in Kerala Gazette on May 13th, 1982. The said notification was purported to have been made under Article 324 of the Constitution of India and has been extracted at such and such page. It may be mentioned that prior to issuing the notification, the Commission had sought the sanction of the Government of India, which was, however, refused. As mentioned above, so and so vote. My lords, will come to para 4. Article 324 of the Constitution gives full powers to the Commission in matters of superintendence, direction, and control of the preparation of electoral rolls, and also for the conduct of elections to the Parliament and state legislatures. It was argued that the Commission, being a creature of the Constitution itself, its plenary powers flowing directly from Article 324 will prevail over any act passed by the Parliament or rules made thereunder. In order to buttress this argument, it was contended that the manner of voting was a matter coming within the ambit of Articles 324 and 327, which empowered the Parliament to make laws in respect of matters relating to or in connection with elections to the Parliament or the state legislature, and would be deemed to be subsidiary to the power contained in Article 324. And if there was any conflict between a law enacted by the Parliament and the powers given to the Commission regarding regulating the conduct of elections to Parliament, that law must yield to Article 324. Otherwise, the very object of Article 324 would be defeated. Notice was given to court. So this was the argument that was made even at that instance. My lords, I'll just read 5 and then do we read 5 or 7? This is a very attractive argument, but on a closer scrutiny and deeper deliberation on this aspect of the matter, it is not possible to read into Article 324 such a wide and uncanalized power which is entrusted to the Commission, as Mr. Jethmalani would have us believe. Part 15 of the Constitution contains Article 324 to 328, which relate to the manner in which elections are to be held, the rights of persons who are entitled to vote, the preparation of electoral rolls, delimitation of constituencies, etc. But this is merely the storehouse of the powers, and the actual exercise of these powers is left to Parliament under Articles 325 to 329. In other words, Article 324 has to be read in harmony with and not in isolation of Articles 326 to 329. And then I will skip that and go to Para 7, my lords. Another golden rule laid down by this court on the interpretation of statutes is that we should so interpret the language of a statute as to suppress the mischief and advance the object. It is true that Article 324 does authorize the Commission to exercise powers of superintendence, direction, and control of preparation of electoral rolls and conduct of elections to Parliament and legislature. But then the article has to be read harmoniously with the articles that follow, and the powers that are given to the legislatures under entry 72 in the Union list, entry 37 in the state list of the 7th schedule to the Constitution. The Commission, in the garb of passing orders for regulating the conduct of elections, cannot take upon itself a purely legislative activity which has been reserved under the scheme of the Constitution only to Parliament and the state legislatures. By no standards can it be said that the Commission is a third chamber in the legislative process within the scheme of the Constitution. Merely being a creature of the Constitution will not give it plenary and absolute power to legislate as it likes without reference to the law enacted by the legislatures. And just para 21, and the rest have already been placed before my lords. Para 21, the pointed and pungent observations rules. Please, my lords. Para 21. The pointed and pungent observations extracted above really amount to a Bible of the election laws as culled out from an interpretation of the provisions of Articles 324 to 329 of the Constitution. and were referred with approval even in Mohinder Singh Gill case. During the last 3 decades, this case has neither been distinguished nor dissented from and still holds the field, and with due respect, very rightly, it continues to hold the field, my lords, even today. No other case ever made such a dynamic and clear approach to the problem, perhaps due to the fact that no such occasion arose, because the Commission has always been following the provisions of the Act and rules.
Saying you were a politician before and after.
The corresponding forms. I want the definition of rules and form in the rules. There's a definition. Please, my lords. And has always been following the provisions of the Act and the rules, and had never attempted to arrogate to itself powers which were not meant to belong to it. The SIR, my lords, is an occasion where it has attempted to arrogate to itself powers which, under the constitutional scheme and judgments laid down by this honorable court, do not belong to it. It is now venturing into the legislative sphere. Indeed, if we were to accept the contention of the respondents, it would convert the Commission into an absolute despot in the field of election, so as to give directions regarding the mode and manner of elections, bypassing the provisions of the Act and the rules, purporting to exercise powers under cover of Article 324. If the Commission is armed with such unlimited and arbitrary powers, and if it ever happens that the person manning the Commission shares or is wedded to a particular ideology, he could, by giving odd directions, cause a political havoc or bring about a constitutional crisis, setting at naught the integrity and independence so important and indispensable to the democratic system, which then goes to the heart of the basic structure. Therefore, my lords, it's my respectful submission that what happens in the pragmatic procedures, whether how many people are left out, whether an appeal is filed or not, what are the numbers? First, the threshold that has to be crossed is it ultra-virus the constitutional scheme? Whether how many people came in or how many people got left out will be able to support or contradict the argument that is being made. But it is my respectful submission, as has been stated earlier from this side, that this is ultra-virus the constitutional scheme as held by this honorable court. My lords would now have a look at the rule. What is this form? My lords had said, why not enumeration form? Apart from the nature of documents, which in itself it creates a systemic disadvantage, my lords would see registration of electors rules 1960, 2C. 2C defines form. Form 6, Form 4, the entire process. Form means a form appended to these rules in respect of any constituency. So every form has to have a legislative sanction. The enumeration form and declaration form are creatures of the ECI with absolutely no legislative authority. Where a process is meant to begin from Form 4, there can be a technological change. We need not say, okay, you have to go to a house or not go to a house. But instead, what is placed here is the enumeration form at page 366 of the volume, which says this will now be the starting point. And that is where the havoc started. My lords would then see as on the issue of plenary powers, that can plenary powers, my lords would just have page 3 of my written submissions. Can plenary powers supplant statutory provisions and rules enacted by Parliament? My lords, the Chief Justice just referred to Mohinder Singh Gill. My lords would have a look at para 38. What is the page number of? 31.
Para 38 of Gill.
38, 39 and 92, my lords. What is the page number?
31. Yeah, it's from 31.
Page, MSK. Oh. There was a list given, I don't know. Huh?
If you have a readily, you can.
I can just,
Whatever.
I can read. Yes. Just.
Actually, Mahendra Singh Gill is so often cited. What a celebrated judgment. And
yes, yes.
almost like a law curriculum that each one of you remember.
My lords, that's right. That is why they call it the Bible of understanding constitution and. My lords, I'm referring to para 38. Article 3324, which we have set out earlier, is a plenary provision, vesting the whole responsibility for national and state elections and therefore the necessary function. It is true that Article 324 has to be read in light of the constitutional scheme and the 1950 Act and 1951 Act. Sri Rao is right to the extent that he insists that if formalized in Article 327, the Commission cannot shake itself free from the enacted prescriptions. My lords will then come to para 39 and the supremacy, just one more line, and the supremacy of valid law over the Commission argues itself.
What earlier you used to cite here? Oh, no, that now we are hearing, but
we had given a list in advance for the books to be pulled out.
Scrolling on the
Volume 5, part 1.
the judgment, they put it on the screen.
You can give a count.
Yes, I did give the list in advance so that the court would have it before it.
No, this is the demotion after coming to court number 1 and 2. They used to.
Yes, yes.
In court 2 used to get it.
At least that facility should be available.
Maybe that.
It's in which volume?
There might be some issue.
Volume 5, part 1 has the judgment also. The volume we have filed.
That's fine, but what is the hiccup here? Why? Is there any problem?
At page 110 of volume 5.
Do a trial after the court trial. Yes, please.
I'm grateful. And the supremacy of valid law over the Commission argues itself. No one is imperium in imperio in our constitutional order. This is the last part of 38. It is reasonable to hold that the Commissioner cannot defy the law armed by Article 324. Likewise, his functions are subject to norms of fairness and he cannot act arbitrarily. Unchecked power is alien to our system. Para 39. Even so, situations may arise which enacted law has not provided for. Legislators are not prophets, but pragmatists. So it is that the Constitution has made comprehensive provision in Article 324 to take care of surprise situations. That power itself has to be exercised not mindlessly, nor malafide, not arbitrarily, nor with partiality, but in keeping with guidelines of the rule of law and not stultifying the presidential notification nor existing legislation. More is not necessary to specify, less is insufficient to leave unsaid. Article 324, in our view, operates in areas left unoccupied by legislation, and the words superintendent's direction and control, as well as conduct of all elections, are the broadest terms. Myriad maybes too mystic to be precisely presaged may call for prompt action to reach the goal of free and fair election. It has been argued this will create a constitutional despot beyond the pale of accountability, a Frankenstein's monster who may manipulate the system into elected despotism. Instances of such phenomena are the tears of history. To that, the retort may be that the judicial branch, at the appropriate stage, with the potency of its benignant power and with the leading strings of legal guidelines, can call the bluff, quash the action, and bring order into the process. Whether we make a triumph or travesty of democracy depends on the man as much as on the great national parchment. Secondly, when a high functionary like the Commissioner is vested with wide powers, the law expects him to act fairly and legally. I'll just read the last two sentences of this. If it is misused, certainly the court has power to strike down the act. This is well established and does not need further case law confirmation. Moreover, it is, and then I will leave that. and come straight to para 92. My lords, these words ring true. It is also very evocative always to read these judgments, which were looking perhaps quite futuristic and looking into what challenges may come our way. Para 92, my lords.
Yes, diffusion.
Diffusion, even more elaborate discussion, tends to blur the precision of the conclusion in a judgment, and so it is meet that we synopsisize the formulation. Of course, the condensed statement we make is for convenience, not for exclusion of the relevance or attenuation of the binding impact. For this limited purpose, we set down our holding. My lords, I'll go to 2A. The Constitution contemplates a free and fair election and vests comprehensive responsibilities of superintendence, direction, and control of the conduct of elections in the Election Commission. This responsibility may cover powers, duties, and functions of many sorts, administrative or other, depending on the circumstances. B. Two limitations at least are laid on its plenary character in the exercise thereof. Firstly, when the Parliament or any state legislature has made valid law relating to or in connection with elections, the Commission shall act in conformity with, not in violation of such provisions, but where such law is silent. Article 324 is a reservoir of power to act for the avowed purpose of not divorced from pushing forward a free and fair election with expedition. Secondly, the Commission shall be responsible to the rule of law, act bona fide, and be amenable to the norms of natural justice insofar as conformance to such canons can reasonably and realistically be required at its fair play. My lords, I'll just pause here. There is no legislative vacuum. The reasons that were cited, migration, deaths, the last SIR done in 2003, so 2 decades have passed. There has been duplication. Many people are complaining of duplication, so it needs to be cleaned and brought into some integrity, has to be restored. The forms that are available from under the rules, from Rule 8 onwards, those forms are designed for precisely these actions. Where is the legislative vacuum? There is no legislation where a silence. There is no place where it says this particular thing cannot be done. Summary revisions, SIR have all been conducted with these forms. Why the need to bring in through an executive action, an administrative order, an enumeration form? It's in a communication. They are addendums to a communication. An enumeration form and declaration form which today overrides what has been passed by Parliament. They have no power and they cannot take cover under 324. 324 does not protect them, and 324 was not designed for that, as has been interpreted by this Honorable Court. My lords, before I go there, I will just point out, and I don't think that file will be before you, my lords, because in the reply to the petition filed by Dola Sen for West Bengal, a TMC MP, I'm told, the petition number being 1074 of 2025, a counter affidavit has been filed by the Election Commission. I'm only referring to it in terms of the legal propositions they have advanced. There is a slew of judgments they have cited where they are saying why 324 and judgments of this court comes to their number 1074 of 2025, dated 28th November 25. Name is Dola Sen versus Election Commission of India. There is a counter affidavit which has been filed by the ECI. I am only going to refer to the legal propositions they have. Where is that page? There are some judgments they have referred to. And I went through that just to see what, because in our counter, these legal propositions were not advanced. And it will come up later. We can't take more time of this Honorable Court. There are few judgments that they have cited. However, unfortunately, they have extracted certain paragraphs. If the entire judgment is read, it can either be very easily distinguished or actually relies upon Mohinder Singh Gill and A.C. Jose in the very next paragraph. So if we are going to extract one paragraph and place before this court, I'm not sure what headway we will make. My lords, there is one judgment, which is special reference number 1 in re Gujarat Assembly election matter. I will just give a list also, where the issue, it came through a reference, and the paragraph cited in the counter affidavit is para 76 of the judgment, which, just keep it open, which says that ECI possesses plenary powers. Parliament cannot curb those powers through invocation of Article 327. This is cited from para 76. My lords, we will just go to the very next paragraph.
It is in light of the aforesaid discussion.
Please, my lords. Please open that. Yeah. Open the judgment. My lords, may I just go to the very next para? And para 76, 78 and para 126, where the opinion, para 126 is the opinion of Honorable Justice Pasayar, where it cites a catenary of cases, including relies upon AC Jose and MS Gill, and supports the argument that Article 324 operates in the field unoccupied by legislature, and the words superintendent's control and direction are controlled by the statute made by Parliament. Open 76 to 78.
126.
Huh? Open 126. Give me 126. That's enough. My lords, I'll just read from the special reference matter, which they have cited in their support. In light of the aforesaid discussion, there is an extraction done from it, from what is reproduced in the counter affidavit. But if you go further down in it, I won't read the whole thing, it'll take too much time. Yes. In the middle of the para, it says, however, I'm reading in the middle of the para, my lords, of para 76. However, care was taken not to leave the entire matter in the hands of the Election Commission, and therefore...
Para 76, we don't know, SEC, it is in light of the aforesaid...
Yes, my lords. My lords is right. It starts with that. I'm grateful. It is in light of the aforesaid discussion, Article 324 was enacted, and the superintendent's direction and control and conduct of elections was no more left in the hands of the executive, but was entrusted to an autonomous constitutional authority, i.e. the Election Commission. It appears that since the entire matter relating to the elections was entrusted to the Election Commission, it was found to be a matter of no consequence to provide any period of limitation for holding fresh elections. This was about conducting elections, whether legislative assembly elections should be conducted just now or not, in this reference.
That's why the day before, when Dr. Singhi was arguing,
yes,
I said that 327, when I use this word, because I was recollecting this judgment line.
I'm very grateful, my lord.
I said that when 327 probably will not tinker with the plenary power of 324. This line I had borrowed from this judgment only.
But my lords, it actually goes ahead to then argue very differently and hold very differently.
But this line somewhere in my mind was from here.
It says so in the beginning of the para. But my lords, in the middle of the para now it says, however, care was taken not to leave the entire matter in the hands of the Election Commission. And therefore, under Article 327, read with entry 72 of List 1 of the 7th Schedule of the Constitution, Parliament was given power, subject to the provisions of the Constitution, to make provisions with respect to matters relating to or in connection with election of either House of Parliament, etc. I'll skip a few lines and go down to where it starts from, thus Parliament. Thus, Parliament was empowered to make law as regards matters relating to conduct of election of either Parliament or state legislature without affecting the plenary powers of the Election Commission. In this view of the matter, the general power of superintendent's direction, control and conduct of election, although vested in the Election Commission under Article 324, yet it is subject to any law, either made by Parliament or state legislature as the case may be, which is also subject to the provisions of the Constitution. The word election...
The constitutional supremacy, basically.
And if there is parliamentary enacted law, that will reign supreme. And here they hold that they are relying upon MS Gill and AC Jose. My lords would then go to, then they cite in para 78, they discuss MS Gill and AC Jose. My lord will then go to para 126. Because this has been cited by them in their support, but my reading of it is that it actually does not support their proposition. This is Justice Pasayat's opinion in para 126. The old articles of the Suprema Lex meets new challenges of life. The old legal pillars suffer new stresses. So we have to adopt the law and develop its latent capabilities if novel situations as here are encountered. That is why in the reasoning we have adopted and the perspective we have projected, not literal nor lexical, but liberal and visional, is our interpretation of the articles of the Constitution and the provisions of the Act. Lord Denning's words are instructive. Law does not stand still, it moves continuously. Once this is recognized, and the task of the judge is to put on a higher plane, etc. I will not take time reading that. My lords, similarly, just open there. They have cited Election Commission of India versus Ashok Kumar, 2008 SCC 216, which is again a 3-judge bench judgment. This relates to counting of ballots in Kerala Assembly election. In the counter affidavit, para 13 of the judgment is quoted. But if you reach para 20 of the judgment, it relies on MS Gill and Digvijay, which cites Digvijay Mote and says the power conferred to the Election Commission by Article 324 has to be exercised in not stultifying existing legislation. I will just read that one paragraph, para 24. Have they provided the judgment?
List was given.
I had given the list you're giving. Okay, thank you so much. My lords, this is Election Commission of India versus Ashok Kumar. And the para cited in the counter affidavit is para 13. I'm reading para 20. 24. In Digvijay Mote versus Union of India, this court has held that the powers conferred on the Election Commission are not unbridled. Judicial review will be permissible over the statutory body, i.e. the Election Commission exercising its functions affecting public law rights, though the review will depend upon facts and circumstances of each case. The power conferred on the Election Commission by Article 324 has to be exercised not mindlessly, nor malified, nor arbitrarily, nor with partiality, but in keeping with the guidelines of the rule of law and not stultifying the presidential notification nor existing legislation. There is no reason cited why Form 4, Form 6, Form 7 are no longer. They themselves are saying you will apply for inclusion through Form 6. They have not abandoned Form 6. They have not abandoned Form 7. What is the need for the enumeration? What they have done is enumeration form arbitrarily abridges Form 6 and removes certain documents completely arbitrarily, creating a structural systemic disadvantage. And my petition is by 2 social activists. It will directly affect the more vulnerable groups. I have shown data with respect to women, similarly for others. And universal adult suffrage was created to ensure that a citizen, no matter how high or low, has equal vote in this country. And that's their mandate. My lords, then it is Shri Sadiq Ali and another versus the Election Commission, a 1972 judgment, again a 3-judge bench judgment. It relates to election symbol. When Indian National Congress there was a split, they had to decide who will get the bullock cart with the yoke symbol. Now here there were rules made under the symbol rules. And the court held, they have cited para 41 of this judgment. However, what is distinguishable is there was no symbols order.
41, there is also no substance in the contention that has power to make provision.
I'm very grateful. It says Parliament must give due respect to the plenary powers of the ECI.
That's right.
No difficulty, my lords. But this was in a legislative vacuum. They are looking at, you cannot distinguish from the fact, where was the symbol's order? If there isn't one, a dispute between who will get the symbol falls exclusively in the domain of the ECI. And if there is no legislation on it, they will therefore have the power to adjudicate, because that is in furtherance of the election process. So again, the last judgment that I'm referring to, which is cited by them, is Kanhaiya Lal Omar versus R.K. Trivedi, 1985, 4 SC 628. Again, it deals with symbols. There was a legislative vacuum. It is distinguishable from what is today the issue before this court. What is the SIR? SIR is also not a new thing. SIR has been held as per them, the last in 2003, 2004 in different states. I will just read, we don't need to read. You want to? I'll just read para 16, my lords, from Kanhaiya Lal Omar. Even if for any reason it is held that any of the provisions contained in the symbols order are not traceable to the act or the rules, the power of the commission under Article 324(1) of the Constitution, which is plenary in character, can encompass all such provisions. Article 324 of the Constitution operates in areas left unoccupied by legislation, and the word superintendent's direction, control, as well as conduct of elections are the broadest terms, which would include the power to make. And then it relies on Mohinder Singh Gill and A.C. Jose. So that legal proposition is crystal clear and has been settled innumerable times. The reliance placed by them on extracts or in facts which are totally distinguishable is a little puzzling. My lords would now come to page 5 of my written submissions, where my lords, by their own scheme that they are following, the 2003 electoral roll today in Bihar has a value and a premium unlike any other electoral roll. Not the summary revision roll of 25, not the roll on which the 24 general elections were held, but the SIR roll of 2003. And therefore, if you are on that or your grandparents' parents are, it enables you to move into this electoral roll. So what it shows us is that when an SIR is conducted, it secures a presumption of genuineness that endures across generations. An electoral roll finalized through an SIR acquires the character of a legacy record, with those included in 2003 roll continuing to benefit from this presumption, while exclusions in the present roll finalized under the ECI 24 June 2025 order will transmit a presumption of ineligibility to future generations, producing structural disenfranchisement. So it is not any other electoral roll. This is a legacy record. And therefore, in this, if the documents have been arbitrarily curtailed, the impact is not whether I've cast my vote now. The impact is on structural disenfranchisement for generations to come. Beyond the immediate loss of the right to vote, the roll functions as a basic record of identity and residence, with consequences in administrative processes and legal proceedings. Wrongful exclusion, therefore, inflicts a lasting constitutional injury by denying equal moral membership in the polity and impairing the right to participate fully in political life. My lords, the last point, no, I want to show this clause 5B. My lords, much has been discussed on citizenship. I will only draw my lords' attention. I will not get into the aspect of citizenship. If my lords can have volume 4, page 360, so it will spill over from volume 4 to the next volume also. But I think 360 is the last page of, show me mine, is the last page of volume 4. Yeah, 360 is the last. I need page 360 and 361. So if you could please hand over both the volumes. Part 1 and part 2. I want 360. 360 is important. I'm just opening this. Where is this?
Roman 8.
We hope that you will be able to conclude.
This is the last. I will not take more time. I'll just point out what the concern is. My lords, clause 5B. My lords will have clause 5B at page 360 of volume 4, which then spills over to the next one at page 361.
Are you referring to 4A?
4A, 4A, yes. My lords has it. Clause 5B. It's the title, the heading is period of claims and objections. Please, my lords. My lords, I'm only reading 5B. In case ERO/AERO doubts, my lords may just note the word doubts, the In case ERO/AERO doubts the eligibility of the proposed elector due to non-submission of requisite document or otherwise, she will start a suo motu inquiry and issue notice to such proposed elector as to why his name should be. So no difficulty, except I would just request my lords to mark the word doubt, because the doubt is arising because I didn't have the requisite documents now demanded under declaration form. Based on field inquiry, documentation or otherwise, ARO shall decide on inclusion, etc. My lords will come to D. No, where is the reference? No, where is the reference to that? Okay, sorry. I'll just read 5B. ARO shall decide on inclusion of such proposed electors in the final rolls. In each such case, ERO shall pass a speaking order. Also, my lords, also it's very important. ERO will refer cases of suspected foreign nationals to the competent authority under the Citizenship Act 1955 for these purposes. ARO shall exercise ERO's powers independently under section so and so. There is a doubt that has been created in the mind of the ER or ARO because of my inability to provide documents not as per Form 6 but as per declaration form, enumeration form. What does that doubt then crystallize into? I can be referred to the competent authority which is deciding whether I am a foreign national, an illegal immigrant, or a citizen. My lords would kindly see, I may actually later, after the Aadhaar was made available, I will file those forms. When it comes to me being included in the electoral roll, there is a due process. I will be given a show cause notice. I will apply. I have a 2-stage appeal under section 24. But when it comes to my entire citizenship being doubted, on the mere doubt of someone, I am going to be referred to, and then I am going to be proving it over there in a tribunal. What kind of power is this? And what is the basis of that? A suspicion. So it is not an innocent act where you have asked for documents that I may well know. If actually there is somebody who does not come within the prescribed criteria, that would definitely be something that will be looked into. But a suspicion can actually result not just in disenfranchisement, which I may well make onto but to statelessness, and me presenting something before a totally different authority. This jump that it makes, the metamorphosis from doubt to suspicion to then prove your citizenship now. What is the basis of that? The enumeration and declaration form without legislative sanction. I will conclude with just reading Anup Baranwal, which is a judgment, and I think Mr. Bhushan is sitting here. This, if I am not mistaken, is the Chief Election Commission judgment. Volume 5, page 437. Page 437. Page 437, volume 5. I am reading para 401 and 402 only. What is the 5 part 2? Volume 5, part 2. What is the page number? Page 437. 437. Volume 5, part 2, 437. And 401 is on what page? Volume 5, part 2. Anup Baranwal, page 437. Where's Neha? They're saying it starts with volume 5. Volume 5 is the judgments. Yes, yes. Anup Baranwal, what is the page number? 5A. It's 5A.
Anup Baranwal judgment we have. Which paragraph?
Para 4, no, my lords has it. Para 401, my lords.
401.
I'm very grateful.
Page 401.
No, para 401. Paragraph.
This judgment has this much, yes.
My
yes,
lords,
we got 401. This is page 437 of this.
Page 2 to 500. 5.
Yes, we have para 401.
I'm very grateful.
The right to take part in.
I'm very grateful, my lord. The right to take part in the conduct of public affairs as a voter is the core of the democratic form of government, which is a basic feature of the Constitution. The right to vote is an expression of the choice of the citizen, which is a fundamental right under Article 19(1)(a). The right to vote is a part of a citizen's life. It is their indispensable tool to shape their own destinies by choosing the government they want. In that sense, it is a reflection of Article 21. In history, the right to vote was denied to women and those who were socially oppressed. Our Constitution took a visionary step by extending to everyone. In that way, the right to vote enshrines the protection guaranteed under Articles 15 and 17. Therefore, the right to vote is not limited only to Article 326, but flows through Articles 15, 17, 19, and 21. Article 326 has to be read along with these provisions. We therefore declare the right to vote in direct elections as a fundamental right, subject to limitations laid down in Article 326. The court has precedents to support its reasoning. In Unnikrishnan JP versus State of AP, this court read Article 45 and 46 along with Article 21 to hold that the right to education, para 402. Now that we have held that the right to vote is not merely a constitutional right, but a component of Part 3 of the Constitution as well, it raises the level of scrutiny on the working of the Election Commission of India, which is responsible for conducting free and fair elections, as it is a question of constitutional as well as fundamental rights. This court needs to ensure that the working of the Election Commission under Article 324 facilitates the protection of people's voting rights. My lords, it's my humble submission that this particular journey of SIR that the Election Commission has embarked on for the entire country step by step will frustrate and not facilitate the vision of the Constitution. I'm very grateful, my lords.
Thank you. Yeah, please, Ganesh.
Before I get into the details of the application that we had filed regarding deduplication, etc., my lord, I just wanted to, without repeating anything, give a broad overview of what is happening. Lord, for the first time after the first election in 1950, for the first time the Election Commission is creating voters lists from a clean slate. It has never happened in the history of this republic before. This SIR is completely different from the earlier SIRs which were done. The 2003 SIR was, the base was the earlier voters list. From the earlier voters list, after door-to-door verification, etc., additions and deletions to that voters list were being made. Today, this SIR exercise is a de novo preparation of a voters list by asking every citizen to first file the enumeration form along with certain documents, etc. This kind of exercise has never been done before. And why this hurry? Why this hurry? Why is it leading to a situation, my lord, where 30 BLOs have committed suicide? Through this, you are saying that you get enumeration forms filled by crores of people. Every BLO is supposed to get enumeration forms filled of all the people. Go house to house, get enumeration forms filled, etc. What happened to what happens to those who are migrant workers, etc.? How will they fill their enumeration forms? And you have given such a short time window and put such unreasonable pressure. Why? For what? And on top of that, you are saying that we will not follow any norms of transparency. You will not give the voters list in a machine-readable form so that people can analyze, can easily and quickly examine whether your name is there or not there, how many duplicate voters are there, who are the duplicate voters, etc. You are saying that you won't use the deduplication software. You are saying you are not even putting the applications for addition and subtraction, addition and deletion on the website as is required under the election manual. that is why, my lord, those words which were read out by Vrinda in her argument from that judgment, which said that we have to imagine that if you give to the election commission, it can become a despot. And we cannot close our eyes to the fact, my lord, that today a lot of people in this country see the election commission as a despot. This is something which we cannot close our eyes to. And therefore, my lord, that is why our application is largely on transparency.
Let us confine to the pleadings only. Let's not make any sweeping statements.
No, that is there in the pleading.
Who has committed suicide? What were the reasons? Because that will unnecessarily.
So, my lord, what I am saying is,
let us confine to the pleading, the reply, and the response we have given.
Yes, I'll confine myself to that. What I am saying is, my lord, that the exercise that is being done today is a completely different exercise from what has ever been done in this country before. And it is being done in a great unseemly hurry, unholy hurry, if I might say so. And it is being done in a non-transparent manner, with the result that ultimately, my lord, if you have a situation where finally they publish the result in the voters list in final voters list of Bihar, and thereafter, my lord, on the day of the voting, more than 3 lakh new voters were added between the final publication. And if you do not give the voters list as it is being updated in a machine readable form, my lord, people cannot see who's being added, who's being subtracted, and for what reason. So therefore,
do we have finally, because now that Bihar election is over, do we have the final data available readily that after this SIR, what is the overall impact? How many people excluded, how many added, and figure?
So, for example, my lord, the Reporters Collective published a detailed report showing that more than 5 lakh duplicate voters still remained in the electoral roll. Now, this is after this SIR exercise, and they showed that these are duplicates because they took a great deal of effort to convert the roll into a machine readable form. That judgment which the Election Commission keeps citing to say that we can't give it in a machine readable form doesn't say that. All that it says is that for the time being, we are not directing them to give it in a machine readable form. These people, if they want, the political parties, it can convert it, use their own resources to convert it into a machine readable form. Now, if it can be converted into a machine readable form, how is anything going to be affected, adversely affected, privacy or anything else by giving it in a machine readable form? All that it does is allows this exercise of detecting duplicate voters easier. Why do they not want this to be done? Why do they want to make it very difficult for anybody to find out who are the duplicate voters who have been enrolled? And they go on changing the electoral roll from day to day, from time to time. They do not put out the changes. They do not put out the applications for addition, deletion, etc. And I'll come to that. I'll show, my lord, from the manual that this is what the manual required. This is what they are doing. This is what the manual required. This is what they are doing. Because the manual took, and on the issue of citizenship also, Election Commission has given repeated instructions to their election officers earlier, saying that, look, it is not the job of the Election Commission to determine anybody's citizenship. At most, what you can do is, if you have a doubt, refer him to the competent authority. That's all that they can do. Unless the decision of the competent authority comes that so-and-so is not a citizen, until then the Election Commission cannot remove anybody on the ground of citizenship if that person is claiming that I am a citizen of this country. And if he has been on the roll, and that's what, my lord, the Supreme Court said in that Lal Babu Hussain. They said that the very fact that you were there in the electoral roll earlier is a presumption of citizenship, etc. And therefore, if you want to thereafter delete somebody from the electoral roll, you have to give him reasons, give him a notice and give him reasons as to why you believe that he is not a citizen of this country. And that is why, my lord, advisedly in Form 6, the application for addition of a name in the electoral roll only requires a self-declaration. Because how many people have these documents which they are asking for? If one were to go on this basis, that you must produce one of these documents in order to show that you are a citizen, more than 25% people in the country will be removed from the electoral roll. So therefore, and you can't arrogate to yourself an arbitrary power to decide without any guidelines as to how will you decide who is a citizen, who is not a citizen. And that is why Election Commission advisedly said in not one, multiple communications that Election Commission is not to decide citizenship. It has to be referred to the competent authority for their decision. And yet, my lord, this exercise is being done ostensibly on the ground to verify citizenship. This is the problem. It's a very, very serious problem.
We will continue day after.
Very
tomorrow we have a 3-judge bench part of matter of
very well.
Tomorrow. And then though that matter is day after also, but day after we will break that 3-judge bench. We will continue with this.
All right.
My lord, with your lordships.
By your lordships, two judgment.
We will have to discover that it is covered.
With my lord's permission.
Next week.
It should be put in the serial note, otherwise.
Next week, 9th or 10th.
My lords, with your lordship's permission, may I mention item number 38? My lords, I had mentioned the matter today in the morning also. Well, since last 10 to 11 days, the matter is being listed, but it's not being taken up. Well, the pleadings are complete. It's only left for final disposal. Well, may fix a date and please have it on board.
38
Well, it's regarding Bihar Panchayat elections.
Oh, now Bihar Panchayat election is also there.
It's pending.
Lords, Mayor.
The interim order has been passed and the chairman is still holding.
Full bench decision of the Bihar High Court.
It will take 10 minutes to.
Here next week, 10.
Please have it on top of board.
Lords, may I have lordship? May I have a lordship's indulgence, lords?
My lord,
The tenure is going to be over.
All these matters will go either next Tuesday or next Wednesday. We are not adjourning for a longer date. Unless both sides want a longer date.
Item 24 is the Haldwani matter, my lords, that encroachment, my lords. We mentioned because the urgency is that the railway operation suffers. So, my lords, I was requesting next week slightly higher up on the board, otherwise it doesn't.
But has anything been done? The railways have prepared some.
Yes, my lords, we had a joint survey. We have filed affidavits, my lords. Lordship may take it at any convenient date, my lords.
Lords, may I have indulgence?
All right, we take up your, what is it?
24, my lords.
Just a minute. We'll try to take up it on 10th.
Grateful. My lord,
It's in item number 38. The tenure is going to be over, and chairman is illegally holding the office. Please have it on any Wednesday, next Wednesday, on top of.
On 10th, we have already complied with your direction.
My lord, my item.
Grateful, your lordship.
My lord, my item is item 16, my lord. This is 87 accusation. Despite your lordship's judgment, I'm not getting by all these claimants, they are aged people and they are not
Which
getting.
item are you referring, madam?
That Bharat Petroleum Limited, my lord, that item 16 on today's.
Tamil Nadu matter.
Pardon, madam?
Tamil Nadu matter.
No, my lord. It is this land acquisition matter from Madras. Madras.
This what I'm using word Tamil Nadu, you are saying Madras. The same thing.
Sorry, my lord, sorry.
Because may I have the indulgence,
Justice Padiwala was my bench partner, we decided.
Yes, my lordship, they are raised people.
Same matter, madam, we are trying to. reflect.
Order is already there, your lordship.
Item 48.
16th or late.
My lords, Mr. 48.
My lord,
because
16.
may I have the
Logged in, he
indulgence?
wants to make a mention.
Yes, Mr. Dwivedi.
Because yes, the petitioner's arguments will go on tomorrow and Tamil Nadu matters are also listed tomorrow.
Yeah.
No, tomorrow we have a three judge bench matter, parted matter. So this matter will, SIR matter will continue day after.
What I was requesting was that the petitioners may finish Lords on 4th and then the Lordship may hear me on 9th or next week, Lords, Tuesday.
Mr. Dwivedi, let them complete because now that the petitioner side is arguing, we are quite sure the way the arguments are going on, they might take Thursday also.
As a
And
Lordship.
then we will accommodate you.
Grateful, Lords, grateful.
West Bengal is
Listed next week, your
Lordship, all matters are already listed on 9th or 10th, so that date we are not changing. In all other matters, wherever you give a date of their choice.
Milords, item number 48, Milords, with respect to this.
Coming on day after.
Okay.